I'm Alison Parry. I'm a partner at JMW and head of the contentious trusts and probate team here. There are several grounds on which you could contest a will. These are lack of required testamentary capacity, lack of knowledge and approval of the contents of the will, undue influence, a lack of the formalities required for will writing, and also fraudulent calumny, which is where the testator's mind has been poisoned in order to leave his estate in a different manner than he would otherwise have done so. In order to make a will, you need what is known as testamentary capacity. It can be very difficult to show that there was undue influence in the creation of a will because you have to show that somebody was actually coerced into making it. In order to look at evidence in this field, we look at witnesses who may have known the deceased well, and we would also look to obtain medical records to see whether there are any relevant entries in those notes that might indicate their vulnerability to that influence. There are a number of people who may be able to claim for reasonable provision out of somebody's estate. This is a spouse or civil partner, a former spouse or civil partner as long as they've not remarried or formed another civil partnership, a child of the deceased, somebody who was treated as a child of the deceased, somebody who was immediately before the deceased's death maintained by the deceased either wholly or partly, and somebody who was living in the same household as the deceased as husband or wife or civil partners for at least 2 years before their death. Where it's a spouse or a civil partner, the provision you might expect is what is reasonably required for your maintenance in all the circumstances. For anybody else who is seeking to claim, then the test is what is reasonably required for their maintenance. Certain claims have a time limit of 6 months from the date of the grant of probate. It's always advisable to bring it as early as possible because there will be more evidence you can gather sooner to the event. Where a claim concludes with a court hearing at trial, then usually the position is that the loser will be ordered to pay the winner's costs. The court, however, has ultimate discretion over who pays the costs and can make a different order if it feels it appropriate to do so. There are several ways in which you could resolve a dispute without going to court. The most common of these are negotiation between the parties and mediation. To contest a will, it's usually sensible to get a solicitor's advice from the outset. These claims can be quite complex and emotionally draining, and a solicitor will talk you through your concerns and be able to have very much firmly in mind what you want to achieve out of it.